Hello, everyone. Hello, everyone. This is Liane Jackson. I am senior law editor at Forbes, and this afternoon I'm joined by Professor Claire Finkelstein from the University of Pennsylvania. She's also the director of the Center for Ethics and the Rule of Law at Penn. And we are just going to dive right in because the Supreme Court has saved its most monumental ruling for last today, for the last of its session. And Professor Finkelstein, I just want to get your opinion on this decision today, the determination on whether former President Trump is immune from prosecution after special counsel Jack Smith indicted him on 4 counts related to the January 6th insurrection.
So, Leanne, what I said today on Twitter and in other interviews is that I think this is the worst decision that the court has rendered in many, many years, and it will go down as among the worst decisions in the court's history, along with Dred Scott, Lochner v. New York, um, and the Korematsu decision. This is going to be one of these decisions that is reviled for all of history because basically the Supreme Court has put the president above the law with regard to a whole host of actions that the president can take as long as he says that he is exercising his Article 2 presidential authority in doing that. What the court did was to create three categories: a category of constitutionally protected activity, a category of presumptively constitutionally protected activity, and then a category of personal capacity action in which the president is not constitutionally protected and is not immune. And the question, of course, will be what is the size of that third category? But in the first category, the highest level of protection, there is going to be a lot of damage because in that category, the president's actions are not even reviewable. And so, not a court and not Congress, no one can gainsay the president's authority in this domain.
So this is directly about President Trump, but does this place presidents going forward above the law? Is that one of the main concerns, the biggest concerns about this sort of decision?
That is the biggest concern about this decision because I think for all time now, presidents will be able to violate the law, will be able to manipulate the law as long as they claim that they're doing it in the exercise of some presidential capacity, which is directly dependent on their Article 2 authority. And they'll be able to get away with that, most likely, um, because the court is making this unreviewable. So what's not clear is the degree to which federal courts will have the ability to set the boundaries around these three categories, or whether or not presidents will have the ability to say, well, I'm exercising my Article 2 authority here, and so that sets the boundaries of the category. But I think that presidents will have a lot of ability to claim that they are exercising in their not just their official capacities, but their constitutionally protected capacities, because it will turn on the reasons they give for their actions. And you can always find a constitutional basis for your action, given that the key constitutional phrases in Article 2 are so broad. The vesting clause, the take care clause, the commander in chief clause. These are very, very broad grants of authority. And presidents will be able to claim very often that they're acting in that capacity.
Now, Chief Justice Roberts, who authored this opinion, has portrayed it or tried to portray it as a very narrow ruling, but he also gave some sort of really broad sweeps of how courts can look at this and how prosecutors will look at this, that they cannot consider, for example, a president's motives in determining whether or not there's criminal activity. And he also said that, he spoke specifically to Trump about leveraging the DOJ authority to replace electors is not prosecutable.
Right.
Pressuring Pence to reject electoral votes is not prosecutable. What are your thoughts on the fact that they spoke to specific facts related to Trump, but they also gave sort of broad strokes, ways for the president in the future to potentially get away with things, so to speak. If
So that's a really concerning part of the opinion, because it suggests that if President Trump becomes president again and decides to fire Jack Smith, for example, um, that he would be immune to prosecute. First of all, that he would be within his constitutional rights to do that. But first of all, but second of all, that he could not be found guilty for obstruction for doing that. Because one would think that if you fire a special counsel who is investigating you or prosecuting you, that that would be a prime example of obstruction of justice. So, right? But this decision essentially says that Congress doesn't have the authority to create statutes that make the president liable for obstruction, if it would cut into his core constitutional powers. And it says that courts don't have the ability to find a president liable for obstruction if he is acting within his core constitutional competence. So that's a really significant, strikes a really significant blow against accountability for presidents, and says basically that a president can't be found liable for obstruction, at least not as far as any removal of an executive branch official is concerned.
And the court already sort of expanded or narrowed the ability to find obstruction in an earlier ruling related to January.
The Fisher case.
Correct,
Exactly. So between the Fisher case and this case, that really strikes at the heart of obstruction laws applied to presidents.
Now, Professor Finkelstein, what do you think is happening here? There seems to be a pattern that people who are sort of observing that or claiming that there's potentially judicial overreach here, that the Supreme Court is there's delay tactics here. There's sort of coddling of former President Trump's cases in order potentially to benefit him. What do you see as the pattern that may be occurring here, if there even is one?
Well, what's really striking to me is the difference between the Trump v. Vance case, just decided 4 years ago in 2020, and this case, because there's only been one change in the court's identity since 2020. And that's Justice Ketanji Brown Jackson. So, and she did not change the balance significantly. It's certainly not for the more conservative side. And it was a Justice Roberts' opinion in both cases. So you remember in the Trump v. Vance case, which also dealt with immunity, albeit a different kind of immunity, the court was unanimous in finding that presidents were not above the law. And so they seem, just in 4 short years, to have reversed themselves and to have taken a very different position with regard to presidential authority. How did that happen? Well, I think one of the things that happened, which is really striking, is that they are acting now in anticipation of a second Trump presidency. And they are expecting that presidency to be quite lawless. And they maybe, despite holding lifetime tenure, may be afraid. And they may also be afraid of their own accountability, because significant questions have been raised about several of the members' ethics, and they are looking potentially for protection. So that's just a total speculation on my part.
But if you could expand just a little bit on that, they are afraid that what exactly might happen.
Well, they could be afraid of being held accountable for their own ethical problems, and they may be looking towards a potential Trump presidency for protection from him. But they also may be concerned about his promises to seek revenge against political enemies. So he has promised to use the Justice Department to seek revenge against political enemies. He has promised that he will use the Justice Department in lawless ways, and that he will seek to prosecute those who get in his way and those who have um, tried to hold him accountable. And so people may be this may be a reflection of a tide turning in which people are afraid to stand up to him. People are afraid of the consequences.
So potentially moving more towards an authoritarian type of
That's
uh,
right.
scenario in the United States, which a lot of people have complained, to your point, that we are sort of being governed by fiat by a court that is, I mean, the Supreme Court in general is an unelected body. It's an undemocratic body, but now we have this conservative supermajority that a lot of people are concerned about that is not bowing at all to stare decisis, but is creating completely new rules. And to that point, Representative Alexandria Ocasio-Cortez today said on Twitter that she is introducing articles of impeachment against, she didn't say which Supreme Court justices, based on, I guess, a lot of these rulings. She also didn't say specifically which, but it was after this immunity decision that she has said this. She's describing what's happening as an authoritarian capture. What are your thoughts on that? And I mean, of course, Congress is so gridlocked. We'll see where that goes, but it sends a certain type of message. And what are your thoughts on that?
Well, I actually tend to agree with her about the authoritarian capture. I think there's a lot of validity to that perspective. I think that the court, with this decision, has really ensconced a profoundly minoritarian view of presidential power at the heart of its jurisprudence. And that is not a view that I would ever have expected to see the Supreme Court backing. It's a view of, Federalist Society and really extremist, not even mainstream Federalist Society viewpoints. It's the sort of view that Professor John Yoo, my former colleague at Berkeley, defended in Section 5 of the torture memos way back when in 2002, when he said that even a federal statute making torture impermissible would be unconstitutional if it tied the hands of the president. Now that's an extreme view of presidential power, a view that says, you can't, that Congress, it doesn't just tie the hands of the court, it doesn't just eliminate judicial review on the part of federal courts of presidential action, it ties the hands of Congress as well, and says that Congress can't even pass laws restricting the president in significant ways. And so that does start to look like something that she is describing, a kind of authoritarian capture. By individuals, some of whom, not all of whom, but some of whom have shown significant problems in their personal ethics, and maybe seeking, as I said, to immunize themselves from accountability. Now, do I think, however, that introducing articles of impeachment is realistic for those members of the Supreme Court? I do not, because I don't think with the current composition of the two chambers of Congress that we could actually see the impeachment of, or even, on a majority basis in the House. We're not going to see those articles of impeachment go through with a Republican-led House and a bare majority in the Senate. There's not going to be 2/3 voting to convict. So I think it is a performative act, one that makes a point, one that stands up for a certain position, but it's not a realistic check and balance on members of the Supreme Court, unfortunately.
Which I think is what has been problematic from the viewpoint of the left and also moderate Republicans who feel that the Supreme Court has been unchecked and maybe has lost the moderate middle. Of course, Congress is, does have the power to impeach and convict justices, but like as you said, that's very unlikely. But as a final thought, I would like to get your, I mean, you did allude to this a little bit, but your thoughts on the fact that, former President Trump has talked about retribution. The Supreme Court is talking about absolute immunity, at least in the use of core powers of the Constitution, which again, it's still undetermined as to exactly what that means, how far that extends. is the country moving in a direction, the justices are taking a lot of power, giving a lot of power back to the courts. What direction are we seeing? And, like, as you said, they're taking power away from Congress to create certain types of laws, giving a lot to the executive branch as well. What trend are we seeing here, and what are your
Right.
thoughts about what's
Well,
happening?
well, one of the things to notice here about misuse of the Justice Department is that it was particularly striking in the Roberts opinion today that he singled out contact with the Attorney General as part of that core constitutional function that for which a president would be totally immunized. Now that's really striking because we're used to saying that there should be a kind of unofficial separation of powers between the White House and the Justice Department. And this really washes that away to say that, um, members of the Oval Office, because remember, it doesn't just cover the president, it covers all members of the Oval Office, can freely communicate with the Attorney General and presumably his staff. Um, just suggests that using the Justice Department to punish enemies and reward friends could be done all the more freely with no ramifications for the close members of a president's administration or members of the Justice Department, presumably. Though it's not clear whether or not the immunity would extend to them since they're outside the Oval Office. But if this is going to raise a whole host of complicated legal questions that will have to play out, and one fear is that when you have a concept like immunity, even the narrow boundaries that the Supreme Court did set on that concept in today's opinion can be themselves overrun by the logic of that concept, and that it can start to expand further and further. And I'll give you one example of that, which is I filed a brief with 14 national security professionals in the immunity case, in which we argued that even partial presidential immunity would create grave confusion within the chain of command, because you could have an individual in the chain of command who has received an illegal order from which the commander-in-chief is immune for prosecution, but someone lower down in the chain is not immune. And they won't know what to do because they'll face a Hobson's choice of either disobeying their commander-in-chief, in which case they could be court-martialed, or committing an illegal act, in which case they could be court-martialed. So either way, they could be subject to serious legal repercussions if the president starts making illegal orders. And there'll be no risk to him because he'll say, "Oh, I'm acting in within my core constitutional duties because I'm acting as commander-in-chief." So basically, any order that the president would give to the armed forces, he'll claim commander-in-chief authority over, and it doesn't matter how illegal it is.
Yeah, it sounds like at the minimum, it has muddied the waters, and as you mentioned, like separation of powers and the giving of orders, and just a whole host of issues that now will be back in front of the courts potentially, and as you said, potential opportunity for abuse. But I really appreciate your insight and analysis, Professor Finkelstein, on these issues. And I think also, I guess we didn't get to this, but of course, this has delayed the case against former President Trump until after the election. At the least, it's benefited him in that way. So,
Well, I can say something about that if you
yes,
want me to,
please,
which is
please.
there will be significant delays because obviously on remand, this is going to take a long time to sort out official functions and core constitutional functions, because now there are 3 categories, not just 2. It's not just official functions from personal capacity acts, but there's that higher level category of official functions and constitutionally protected official functions, then personal capacity acts. It's going to take quite a long time to sort out. And so the really big risk is what happens if the trial is still ongoing when Donald Trump becomes president. It will be pretty much impossible at that point to continue the trial, especially now, we're sort of going in a circle here, but now that Donald Trump has been given immunity, he can therefore fire Jack Smith, fire anyone involved in the case, and threaten witnesses and do, anything that he wants to do to make it impossible to hold himself accountable. So his bid to stand above the law he's succeeding in that bid, unfortunately.
Yes, this decision has in many ways turned the democratic and judicial process on its head. And this after a lower court and appeals court found that former President Trump was not immune to prosecution. So this was an interesting decision, monumental by the Supreme Court. Again, thank you so much for your thoughts on this. Extremely valuable. And I hope you join us again soon, Professor Finkelstein.
Thanks for having me.